Alright, what's up, guys? We got another one that we are going to cover. Let me play around for just a second, get a couple things squared away. So, this is one of many red flag bills that are being pushed through Congress right now. Let's go ahead and get into this. So, here we go. This was introduced on 4/8 of 2021. This is to authorize the issuance of extreme risk protection orders. Now, I just checked on this a minute ago. There are now 119 Democrats and so far no Republicans, thank God, that have signed on to this bill. And it is making its way through the House right now. So let's look through this giant piece of dog squeeze. And this is our plasma cut for this one. This is our frog marching, communist toting guy, communist flag toting. Because obviously, these Democrats don't believe in personal freedoms or liberties or the Constitution or individual rights or anything like that. And it's not just them. We'll look at another bill later on that has all the same provisions in it, except it was introduced by Marco Rubio from Florida. And a couple of Republicans have signed on to bills like this. So, yeah, let's get into it. So they added in a whole new section into Chapter 44 of 18 U.S.C. United States Code. They add in sections 932, extreme risk protection orders. So starting off with this, they go into definitions. The term designated law enforcement officer means a law enforcement officer designated by the United States Marshal who agrees to receive firearms, ammunition, and permit as applicable surrender under subsection F. So this would be who is going to collect your guns, who is going to collect your ammo, who is going to collect your permit if you have one of these red flag laws against you. Term director means director of the administration office of the United States courts. Ex parte, meaning you don't have to be there. This stuff can just be filed against you. Means extreme risk protection order under subsection C. The term extreme risk protection order means an order issued by a federal court that enjoins an individual from purchasing, possessing, or receiving in or affecting interstate and foreign commerce a firearm or ammunition. Boy, the more I read this, the more it just drives me insane. Interstate or foreign commerce. These people have no power to do this, but they use the Commerce Clause to do it. And the judges on the Supreme Court that actually let this stuff stand originally, and like the 34 NFA challenges and stuff like that, there is no end to the amount of. Yeah, well, now I won't go there either. Trying not to get banned from YouTube. I'm surprised I haven't been yet, but term family or household member with respect to a respondent means any parent, spouse, sibling, child related by blood, marriage, or adoption to the respondent. So that would be the person that they are actually putting the red flag law against. Dating partner of the respondent, individual who has a child in common with the respondent, regardless of whether the individual has been married to the respondent, lived together. Individual who resides or has resided with the respondent during the past year. So yeah, no ex-girlfriend could ever flip her shit, or ex-boyfriend for that matter, and actually press this against you. No, that can never happen. Domestic partner of the respondent individual who has a legal parent-child relationship with the respondent, including a step-parent, stepchild, grandparent, grandchild relationship with individual who is acting or has acted as the legal guardian of the respondent. The term law enforcement officer means any officer, agent, or employer or employee of the federal government or state government, unit of local government, Indian tribe as defined, yada yada yada. Um, Getting down here into a by law or government agency to encourage in or supervise the prevention, detection, or investigation of any violation of criminal law, or by law to supervise sentence criminal offenders. Hey, this is getting like into probation officers and shit. The term long-term extreme risk protection order, and make no mistake, all of these are going to be long-term, means an extreme risk protection order issued under subsection D. The term mental health agency means any agency of the state, that makes me feel all tickly and warm inside, or local government, or its contracted agency that is responsible for mental health services or co-occurring mental health and substance abuse services. The term National Instant Background Check System means the National Instant Criminal Background Check System established under Section 103 of the Brady Handgun Violence Prevention Act, which hasn't prevented shit. Petition. In general, a family member or household member of the applicable individual or law enforcement officer may submit to an appropriate district court of the United States a petition requesting that the court issue an ex parte extreme risk protection order or long-term extreme risk protection order with respect to an individual. 2. No fees. A court may not charge a petitioner any fee for filing a petition under paragraph 1. Confidentiality. A petitioner who is a law enforcement officer may provide the identity of the petitioner's sources and any identifying information to the court under seal. So you wouldn't even know who actually pressed this red flag law petition against you. Could be anybody. Could be for any reason. They just press this against you, show up, take all your shit, and you have very little recourse besides spending a whole lot of money in the courts to get your stuff back. No possibility for abuse in this at all, whatsoever. Ex parte orders, timing in general, except as provided in subparagraph B. A court that receives a petition for an ex parte order under subsection B shall grant or deny the petition on the date on which the petition is submitted. So there's zero time for any kind of investigation in this. They just write the petition, give it to the court, and the court the same day has to say yes or no. All of your rights be damned in this whole situation. You're guilty of whatever for any reason. Late petitions. If a court receives a petition for an ex parte order submitted under subsection B too late in the day to permit effective review, the court shall grant or deny the petition on the next day of judicial business at a time early enough to permit the court to file an order with the clerk of the court during that day. I love how they say in time to there's no review in this. Evidence required. This ought to be interesting. Before issuing an ex parte order, the court shall require that the petitioner submit a signed affidavit sworn to before the court that explains why the petitioner believes the respondent poses a risk or risk of imminent personal injury to himself or herself or another individual by purchasing, possessing, or receiving a firearm or ammunition, and describes the interactions and conversations of the petitioner with, let me get down here, the respondent or another individual. So this could be third party, another individual, if the petitioner believes that the information obtained from that individual is credible and reliable. So this is being obtained by a third party outside of this situation. Yeah, no abuse whatsoever. No, they're not going to kick your door in and take your shit for no reason. All right. Standard for issuance of an order. A court may issue an ex parte order only upon finding of probable cause to believe that the respondent poses a risk of imminent personal injury to himself or herself or another individual by purchasing, possessing, or receiving a firearm or ammunition, and the order is necessary to prevent the injury described in subparagraph A. These things are so freaking ridiculous. You might as well just wad the Constitution up, set it on fire, dance on its ashes if you believe in things like this. Alright, duration. An ex parte order shall expire on the earlier of the date that is 14 days after issuance or the date on which the court determines whether to issue a long term order with respect to the respondent. So they can ramp this up at any time. Hearing required. If a court receives a petition for an extreme risk protection order for a respondent under subsection B, the court shall hold a hearing to determine whether to issue a long-term order with respect to the respondent.
Dad, can I have some more cherry Coke, please?
I don't have any more in there, baby. I'll have to get some more. Either, except as provided in clause 2, not later than 72 hours after the court issues an ex parte order with respect to the respondent, or if the court issues an ex parte order with respect to the respondent, but the order is not served on the respondent within 72 hours of the issuance, not later than 72 hours after the order is served on the respondent, or if the respondent waives the right to a hearing under subparagraph A, the court does not issue an ex parte order not later than 14 days after the date on which the court receives a petition. Notice and opportunity to be heard. In general, the court shall provide the respondent with notice and the opportunity to be heard at a hearing under this subsection sufficient to protect the due process rights of the respondent. If you're going to take someone's property before they're convicted of anything, that is not due process. If you can do this without them even being in the courtroom to object, that is not due process. Right to counsel. In general, at a hearing under this subsection, the respondent may be represented by counsel who is chosen by the respondent and authorized to practice at such a hearing. So if you get the notice that you are being charged under one of these red flag orders, you get to spend the money on a lawyer to try to defend yourself if you actually get the notice to even show up to court. And you have to do all this within 72 hours. Court provided counsel. If the respondent is financially unable to obtain representation by counsel, the court, at the request of the respondent, shall ensure, to the extent practicable, that the respondent is represented by an attorney for the Legal Services Corporation with respect to the petition. They are going to find you the dumbest son of a bitch on this planet who knows nothing about firearms or you or anything else to represent you. Burden of proof standard. At a hearing under the subsection, the petitioner shall have the burden of proving all material facts and shall be required to demonstrate by clear and convincing evidence that the respondent poses a risk of personal injury to himself or herself or another individual during the period to be covered by the proposed extreme risk protection order by purchasing, possessing, receiving firearms or ammunition. There is going to be zero burden of proof in this. There's going to be an allegation. They're going to come take your stuff. Again, no room for this to be abused by anybody. Alright. The order is necessary to prevent injury described in Clause I. Issuance upon showing of clear and convincing evidence. Yeah, right. The court shall issue a long-term order with respect to the respondent that shall be in effect for a period of not more than 180 days. If the court finds that there is not clear and convincing evidence to support the issuance of a long-term order, the court shall dissolve any ex parte order then in effect with respect to the respondent. Renewal. Notice of scheduled expiration. 30 days before the date on which a long-term order is scheduled to expire, the court that issued the order shall notify the petitioner that the respondent, or notify the petitioner and the respondent that the order is scheduled to expire, and advise the petitioner and the respondent of the procedures for seeking renewal of the order under this paragraph. Getting into the petition. If a family member or household member of the respondent or a law enforcement officer, love how they chunk that in there, believe that the conditions under subparagraph 3b continue to apply with respect to the respondent, who is subject to long-term order, the family or household member or the law enforcement officer may submit to the court that issued the order a petition for a renewal of the order. Again, they can keep this going indefinitely. And you are going to be paying for lawyers, you're going to be paying for legal fees to try and get your property back. All without being convicted of a single crime. Okay, let's see. The hearing. A court that receives a petition submitted under subparagraph B shall hold a hearing to determine whether to issue a renewed long-term order with respect to the respondent. And you know, if you looked at anything on our courts, they're going to issue it. They're going to let it ride. Applicable procedures. The requirement under paragraph 2 through 5 shall apply to the consideration of a petition for renewed long-term order submitted under subparagraph B of this paragraph. God, you gotta love reading legal crap. Issuance upon showing by clear and convincing evidence. Now that's going to be clear and convincing evidence to the court. And they can find anything to be clear and convincing evidence. Your social media, this YouTube channel, clear and convincing evidence. You don't have to make threats to anybody. There's no proof of violence. No convictions. Nope. All your rights are just gone. Let's see. Clear and convincing evidence. Conditions under subparagraph 3b continue to apply with respect to the respondent. The court shall issue a renewed long-term order with respect to the respondent. Factors to consider in determining whether to issue an extreme risk protection order. A court shall consider factors including recent threats or acts of violence by the respondent directed towards other individuals. Realize that could be a fight with somebody and you push them. You could tell someone that they just need their ass kicked, which there are a lot of people on this planet that definitely need their ass kicked. Recent threats or acts of violence by a respondent directed towards himself or others. Recent acts of cruelty to animals by the respondent. Ever trained a puppy and rubbed their nose in something and swatted him with a rolled up newspaper? Evidence of recent criminal offenses by the respondent that involve controlled substances or alcohol. So the person accusing you of something could say that you like to smoke weed. They could accuse you of drinking too much. Ongoing abuse of controlled substances or alcohol by the respondent. They may consider other factors, including the reckless use, display, or brandishing of a firearm by the respondent. Ever been to a range? Someone could say that you're reckless with a firearm. History of violence or attempted violence by the respondent against other individuals. And prior involuntary confinement of the respondent in a hospital for individuals with psychiatric disabilities. Relinquishment of firearms and ammunition. Order of surrender. Upon issuance of an ex parte order or long-term order, the court shall, order the respondent to surrender all firearms and ammunition that the respondent possesses or owns in or affecting interstate commerce, as well as any permit authorizing the respondent to purchase or possess firearms, including a concealed carry permit. Because in some states you can use your concealed carry permit as a background check. They don't have to run a 4473. You show them the permit, that it's valid. You can purchase a firearm without the background check. And when they're talking about surrendering these things, they are talking about the law enforcement coming to your home and taking these items from you at the point of a gun, mind you. So let me get this straight. You think someone is a danger to themselves or others, possibly a violent person. So what you want to do is put them in direct conflict with armed people. We've already seen this happen in one or two cases where a person was not real happy with giving up their firearms and ended up getting killed by law enforcement with no proof that this person was in fact a real danger to themselves or others. It's why I've said many times before, and I will say it again: the left in this country, leftists, um, and some people who are supposed to be Republicans, are not against violence. They just want to subcontract their violence out to the state. They have no problem sending people with guns to your home to take your property or possibly kill you. That doesn't matter to them. So let's see. They're talking about United States Marshal Service, a designated law enforcement officer, surrender and removal, manner of service, professional service except as provided under Clause 2. The United States Marshal or designated law enforcement officer shall serve an extreme risk protection order under or order on a respondent by handing the orders to the respondent. So you're sitting around in your living room on a Wednesday evening, not doing a whole lot of anything, watching TV. You get a knock on the door. There's a bunch of armed people out there handing you a sheet of paper and saying they are now going to collect all of your firearms, your ammunition, and any permits you hold. You haven't been in court yet. You haven't been convicted of anything. You haven't even been asked any questions. But here it is. Alternative service. If the respondent cannot reasonably be located for service as described in Clause I, an extreme risk protection order may be served on the respondent in any manner authorized under the federal rules of civil procedure. That is civil asset forfeiture, because they are taking your property without compensation. In fact, it is going to cost you money to get your property back. Removal, except as provided in subparagraph C, a United States Marshal or designated law enforcement officer serving an extreme risk protection order may personally, on the respondent, or I lost my whole train of thought. Serving extreme risk protection order personally on the respondent shall request that all firearms and ammunition affecting interstate commerce, as well as any permit authorizing the respondent to purchase or possess firearms, including concealed carry permits, that the respondent possesses or owns, be immediately surrendered to the United States Marshal or designated law enforcement officer at the option of the respondent, be immediately surrendered and sold to a federally licensed firearms dealer. What? So I have the option, if they're going to come take my property, to sell them to an FFL? Take possession of all firearms and ammunition described in Clause I that are not sold under subclause 2 of that clause, as well as any permit described in that clause that are surrendered in plain sight or discovered pursuant to a lawful search. So there goes your Fourth Amendment rights. So they just get to go in and search, even though there's no crime, haven't been convicted. Oh, man. Anybody who is for these laws, these extreme risk protection orders, I would really like it if you guys got the joy of having to go through something like this. Alternative surrender. If a United States Marshal or designated law enforcement officer is not able to personally serve an extreme risk protection order under subparagraph AI, or is not reasonably able to take custody of the firearms and ammunition or permits under subparagraph B, the respondent shall surrender the firearms, ammunition, and permits in a safe manner to the control of a United States Marshal or designated law enforcement officer not later than 48 hours after being served with the order. Oh boy, this keeps getting better. Receipt issuance. At the time of surrender or removal under subparagraph 2, a United States Marshal or designated law enforcement officer taking possession of a firearm, ammunition, or a permit pursuant to extreme risk protection order shall issue a receipt identifying all firearms, ammunition, and permits that have been surrendered and removed, and provide a copy of the receipt issued under Clause I to the respondent. Not later than 72 hours after service of an order under subparagraph 2A, the United States Marshal who served the order or designated law enforcement officer shall file the original receipt issued under subparagraph A of this paragraph with the court that issued the extreme risk protection order and shall ensure that the United States Marshal Service retains a copy of that receipt. Designated law enforcement officer. If a designated law enforcement officer issues a receipt under subparagraph A, the officer shall submit the original receipt and a copy of the receipt to the appropriate United States Marshal to enable the United States Marshal to comply with subparagraph B. So all this is going to be done through the Marshal Service. They could designate your local sheriff's office, come out and do this, and then the local sheriff's office has to submit all the paperwork to the U.S. Marshals. And then the Marshals have to file it with the court. Forfeiture. If a respondent knowingly attempts, in violation of an extreme risk protection order, to access a firearm, ammunition, or a permit that was surrendered or removed under this subsection, the firearm, ammunition, or permit shall be subject to seizure and forfeiture under 924D. Return of firearms and ammunition. If an extreme risk protection order is dissolved or expires and is not renewed, the court that issued the order shall order the United States Marshals to confirm through the National Instant Background Check System and any other relevant law enforcement database that the respondent may lawfully own and possess firearms and ammunition. So you're a lawful gun owner. They take your stuff. You've not charged with anything. They then take the time to run further background checks on you to see if you can still own these things. If the respondent may lawfully own and possess firearms and ammunition, notify the respondent that the respondent may retrieve each firearm, ammunition, or permit surrendered by or removed from the respondent under subparagraph or subsection F, or if the respondent may not lawfully own or possess firearms and ammunition, notify the respondent that each firearm, ammunition, or permit surrendered by or removed from the respondent under subsection F will be returned only when the respondent demonstrates to the United States Marshal Service that the respondent may lawfully own and possess firearms and ammunition. If an extreme risk protection order is dissolved or expires and is not renewed by the United States Marshal Service, confirms under paragraph 1A that the respondent may lawfully own or possess firearms and ammunition, the court that issued the order shall order the entity that possesses each firearm, ammunition, or permit surrendered by or removed from the respondent under subsection F to return those items to the respondent if they haven't been turned into paper clips yet. Return of firearms and ammunition return of firearms and ammunition improperly received. If a court in a hearing under subsection D determines that the firearm or ammunition surrendered by or removed from a respondent under subsection F is owned by an individual other than the respondent, the court may order the United States Marshal or designated law enforcement officer in possession of the firearm or ammunition to transfer the firearm or ammunition to that individual if the individual may lawfully own and possess firearms and ammunition. The individual will not provide the respondent with access to the firearms or ammunition. So it'd be like if you had borrowed a gun from somebody, and then one of these red flag laws is put in action against you, they would return that gun back to that person. I'm sure after they run all serial numbers. And penalty for false reporting or frivolous petitions. An individual who knowingly submits materially false information to the court in a petition for an extreme risk protection order under this section, or who knowingly files such a petition that is frivolous, unreasonable, or without foundation, shall be fined not less than $1,000 in addition to any other penalty authorized by law as the court deems necessary to deter such abuse of process. We all know that will never, ever come into play. It's the same reason that, to use an example, a woman can accuse a man of rape in situations where the man has not raped her, and that guy will go through 9 kinds of hell and have his life destroyed, and, well, nothing will ever happen to her. I'm kind of the mind that if a woman accused me of rape, whatever my sentence would have been when I am proven innocent should be her sentence for accusing me of that crime. So if I was going to go away for 20 years and all of a sudden I am proven innocent, well, she gets to ride for 20 years. Let's see. Model policy in general. The director shall draft a model policy to maximize accessibility of extreme risk protection orders. In drafting of the model policy under paragraph 1, the director shall ensure that the state, local law enforcement officers, and members of the public without legal training are able to easily file petitions for extreme risk protection orders, prescribe outreach efforts by employees of the district courts of the United States to familiarize relevant law enforcement officers and the public with procedures for filing petitions, either through direct outreach or in coordination with relevant officials in the executive or legislative branch of the federal government, or with state and local officials, prescribe policies for allowing the filing of petitions and prompt adjudication of petitions. Hold on, guys. I got to do something. Alright, I'll see whether I can edit that back. My son come and got me. He had something going on. So where are we at? Let's see. Prescribed policies for filing petitions. Prescribed policies for coordinating with law enforcement agencies to ensure safe and timely, effective service of extreme risk protection orders, relinquishment of firearms, identify government and non-governmental resources and partners to help officials of the district courts of the United States coordinate with civil society organizations to ensure that the safe and effective implementation of this section. Oh, good God. In general, not later than 2 court days after the date on which a court issues or dissolves an extreme risk protection order under this section, or an extreme risk protection order expires without being renewed, the court shall notify the Attorney General. Each relevant mental health agency in the state in which the order is issued, and state and local law enforcement officials in the jurisdiction in which the order is issued, including the National Instant Criminal Background Check System, single point of contact for the state of residence of the respondent where applicable. A court shall submit a notice under subparagraph A in an electronic format in a manner prescribed by the Attorney General. Updates of database as soon as practicable and not later than 5 days after receiving notice under subparagraph A, the Attorney General shall update the background check database of the Attorney General to reflect the prohibitions articulated in the applicable extreme risk protection order. Annual reports, not later than 1 year after the date of enactment of Federal Extreme Risk Protection Order Act of 2021, and annually thereafter, the director shall submit to Congress to the Committee on the Judiciary of the Senate and the Committee on the Judiciary of the House of Representatives a report that includes, with respect to the preceding year, the number of petitions for ex parte orders filed, as well as the number of such orders issued and the number denied, number of petitions for long-term orders filed, as well as the number of such orders issued and the number denied, number of petitions for renewals of long-term orders, as well as the number of such that were denied, number of cases in which the court has issued a penalty for false reporting or frivolous petitions. That number is pretty much always going to be 0. Technical and conforming amendments. Let's see. So, table of sections for Chapter 44, 18 United States Code is amended by adding at the end the following. This is the section that we're looking at, which is 932, the extreme risk protection orders, forfeiture, which is section 924D3, which allows the forfeiture. Any attempt to violate an extreme risk protection order issued under 932, that's all your seizure and forfeiture stuff. Brady Act petitions, so section 922 of the Title 18 United States Code, and subsection D, by striking or at the end, and then adding in this, which is subject to court order that prohibits the person from purchasing, possessing, or receiving a firearm or ammunition. And at the end, okay, so they're just adding that into 922, making it an unlawful act for anybody underneath one of these red flag orders to purchase another firearm, buy ammunition, anything like that. And serviceability. Again, like a lot of these laws, the serviceability says that if any one part of this act is proven to be unconstitutional, that the rest of the act will continue on without that one act. Oh, good Lord. That's it for that one, guys. This is one of the many red flag laws that are being proposed in Congress right now, signed on to by a ton of people. Some Republicans are actually proposing bills like this, like Mr. Marco Rubio from Florida. So if you guys in Florida would be nice enough to never vote for that little moron again, it would be awfully nice for the rest of us in the United States. And I'm out. Y'all be cool.